Why possession is important? Possession is essential instrument for transferring right of control. By having a document in your hands, you have the rights which are embodied in the document. I like this German expression because that actually hits the essence. Das Recht aus dem Papier folgt dem Recht am Papier. The right on paper follows the right from the paper. So by having a certain rights on the paper, you also have the rights which are embodied in the paper. So by transferring a bill of lading, by transferring a bill of exchange, you transfer certain rights. By transferring bill of exchange, you transfer the right to receive the money from the bank. By transferring bill of lading, you transfer the right to receive the goods from the carrier. So basically, the document is important. The possession of the document is important. By endorsing, by transferring a document, you also transfer the rights which are embodied in the document. And in case of bill of lading, what are the rights which are embodied? Is the right to receive the goods from the carrier, the right to sell the goods, to dispose of the goods, and right to give instruction to the carrier. Bill of lading does not give you property right. That's important because always students are confusing because it's called document of title, but this title is not property right. It's a right to receive. It's contractual rights, which is based on bill of lading. In practice, very often it does transfer property, in practice. But by nature, who issues bill of lading is the carrier. The carrier, he doesn't care who is the owner of the goods. The carrier is not allowed to deliver the goods to the owner of the goods if the owner does not have bill of lading. Because the owner of the bill of lading may be different from the owner of the goods. Maybe freight forwarder who may have certain rights which are guaranteed by having a bill of lading, right to receive his fee from the real owner. So what is the right which is embodied is the right to receive the goods and to transfer the rights on the goods by transferring bill of lading. Possession is a key here, of key importance. As Patrick mentioned, bill of lading has three functions: is receipt for the goods, is evidence of contract, and document of title. First two functions are no problem. In practice, you can prove the contract, you can prove receipt, but the issue is how you can transfer the rights, how to replicate the document of title. Then we come again to the issue of possession. As I mentioned before, paper documents are capable of playing their function not because they are on paper, but because what they represent. As I mentioned, it's we can use any other instrument instead of paper, but paper is the most convenient for that. Electronic documents do not have to perform the functions of paper in the same way, which means you don't have to have possession. You can do it other way. And the issue is, what is the other way? How to replicate, or once I use the cloning possession, how to do it another way that will be legally valid. Unstable model law relies on the concept of exclusive control. So control actually was first mentioned by Rotterdam Rules. Rotterdam Rules, coming to Patrick, I hope Rotterdam Rules will never enter the force. Why? Because, okay, Rotterdam Rules were supposed to unify law of carriage of goods, because now we have Hague Rules, original, which is United States, Hague Rules, Hamburg Rules, 3. With Rotterdam Rules, we would not have 3, we would have 4. English, most likely, very likely, would never ratify. And English law dominates carriage of goods. About 80% of all carriage goods disputes end up in English courts, English. So if English don't ratify, even if EU ratifies, okay, we will have Rotterdam Rules in force, but this would actually increase fragmentation, not reduce. So I hope Rotterdam Rules will never enter into force. So exclusive control, coming back to model law. is supposed to, that was a kind of solution found, to play this kind of role of replicating possession. Instead of having a document in your hands, tangible, in case of intangible documents, you would have the right of control. And I think that was a major contribution of Rotterdam rules. They introduced the concept of control, right of control. A right of control has the one who is lawful holder of bill of lading. That is expression that was used in Rotterdam rules, or who would have exclusive control in case of electronic transport documents. Okay, so it's basically what is the result? The one who has exclusive control is in the same position as the lawful holder of bill of lading in case of paper documents. So it's the same position. And that is important element, which I think American UCC was kind of anticipating this, but of course it was logical to have this. Exclusive control is focused on using reliable methods to identify the person in control of electronic record. That's of key importance. You must have security. And then master model uses this term of singularity, because what is important to have exclusive control, only one should have control, only one person. Otherwise, the concept is lost, fails. So what is important is to ensure that no other person can have control. Only one person should have control. And what Patrick once mentioned, the CMI, that was very important contribution. They introduced the concept of a private key. So private key is actually something which is used also by blockchain that guarantees that you are the one who has control over the goods. Oh, sorry. Transfer of documents. Yes. Okay. That is what are transferable documents, as I mentioned, because I think it's important to compare. One of the issues that I would like to do today is to compare electronic transferable documents and electronic trade documents. And this is copied from explanatory notes of ancestral model law. Transferable documents or instruments are paper-based documents or instruments that entitle the holder to claim performance of obligation indicated therein, and that follow the transfer of claim of that performance by transferring document or instrument. This is something which corresponds to civil law concept of, we call it in Croatian, vrijednost papiri, vertapire, titer in French, etc. So this is basically corresponds to that kind of broad concept. And according to this same explanatory note, transferable documents include bills of exchange, checks, promissory notes, consignment notes, bills of lading, warehouse receipts, insurance certificates, and airway bills. Few questions I have. I don't understand why they put, for example, consignment notes. Is consignment not transferable document? When I studied law, this was not transferable document. I'm not sure, maybe something changed in time. But consignment note is actually a document issued by consignor, sender, and serves as receipt. I delivered the goods to railway company or truck company. It also contains contractual terms, but it does not have rights. It does not carry any rights as a paper. Airway bill, that is something new for me, that this is transferable document. As far as I know, unless maybe there is some new developments that airway bill can be made transferable, but as far as I know, that is basic distinction. On one side you had consignment notes and way bills, on the other side you have bill of lading. Bill of lading enables the holder to transfer right in the transit because carriage by sea is longer and you need that. Airway bill, you don't. Why you would transfer airway bill? Just for a few hours of flight? What is the purpose of transferring airway bill? I don't understand. I'm not sure this is wrong, but I don't understand, to be frank. They also mention letter of credit. May be considered transferable document or instrument in some jurisdictions. Is there any jurisdictions that would recognize letter of credit as transferable document? If you read UCP, you can see that it can be issued as transferable, but only once. And I think Article 38D maybe, that second beneficiary is not allowed to transfer further. Can be transferred only once. So this is not transferable document in the sense of electronic transfer documents, which can be transferred and circulate, because this is not something that is the purpose of transferable letter of credit is completely different. When you have middlemen and then you need someone that would finance, and then you would get money because you know source of supplier, and this is not transferable document as far as I know. But okay, I'm disclaiming that maybe there is something I don't know. Okay. Then it does not cover trade bills of lading. Is this transferable document? It's not negotiable, but is it transferable? This is something which corresponds to bill of lading to a named person. Can you transfer bill of lading to a named person? By assignment? So it's not negotiable, but it might be transferable. It's not transferable in practice because it's complicated. So you don't. Something strange happened in English law with regard, because this is concept from English law. Originally, it derived from Pomeranian Act, American law, but now they abolished. They have introduced very practical solution: negotiable, non-negotiable documents. That's it. And this was supposed to. Actually, there was a confusion with Seaway bill, but Seaway bill and straight bill of lading are different documents, very different documents. In case of Seaway bill, this is non-negotiable, and you deliver the goods to the person named in the person, in the document. In case of, you don't need to produce it at the destination. It was introduced just to avoid the problem of delays, but straight bill of lading is document of title. And it was a famous case, Rafaela S. 2001, I think it's Bernard Ricks, who is now a professor at Queen Mary, who delivered judgment. It was very brave judgment because it contravened Carriage of Goods by Sea Act 1992. Under Carriage of Goods by Sea Act, bill of lading to named person is not document of title. So he went against law of own country. So now if you ask me, is a straight bill of lading document of title under English law, my answer will be, it depends. Whether it's statutory law, which is, you have still Carriage of Goods by Sea Act, which says it's not document of title, but if you look at case law, it is document of title. So if you look at textbooks, Carver, for example, previous edition, you don't have to produce straight bill of lading because it's not document of title. Now in new edition, you have to produce a straight bill. So it's a bit confusing. I think English have to do something about that. So this kind of confusion is, from my perspective, is not acceptable. It depends. Should not have this kind of solution in law. Laws must be clear, not leaving that kind of doubt. Concept of exclusive control. Possession implies exclusivity in exercise. So basically, what is the meaning of exclusivity? It clarifies the concept of control, because you can have different kind of control. One of the problems which is not solved at the moment is what is control. Control is not solved. It's not defined. But if you use the term exclusive control, this helps clarifying that the only one person can have control over the goods. Transfer control requires identification of the person to whom electronic document was issued or transferred. So must have clear identity of the person who has exclusive control. Fundamental condition is the method employed to fulfill all requirements regarding identification must be reliable. So we come back again to Astra model. This is something of essential ingredient of this concept. To have exclusive control, you must have a kind of security that only one person and no others. There should be no abuse, no kind of interference. Must be clear and safe. United States, as I mentioned, has in a way anticipated Astral model law. Probably it it had influence. I know Henry Gabriel, who was one of drafters of UCC, he was also a member of Anstral Commission. So he was on both sides. I guess he was the one that took part in drafting of Anstral model law on the basis of UCC, because the concepts are very similar. Just that they use the term electronic document of title. This is section 706, which is of most important. A person has control of the electronic document of title if a system employed for evidencing the transfer of interest in electronic document reliably establishes that person as the person to which electronic document was issued or transferred. So they provide for the control as substitute for possession. So basically now you have solved the problem under American law. So electronic transport documents are recognized as legally effective document of title. So you can see that you can do it by legislation. Okay, they have conditions which are very similar to Anstral model law, which are conditions for reliability. Germany, we go to some civil law country. Germany has made some important steps in that direction. They have revised Handelsgesetzbuch 2013 and recognize use of some electronic trade documents, including bills of lading, warehouse receipts, again consignment notes. So I might miss something. They adopt a parallel legal regime that applies to these documents based on principle of functional equivalence. So they use the concept which actually was developed originally by Anstral model on electronic commerce, which is very practical way. That was very practical way to solve the problem of different. Instead of creating a new legal framework for electronic documents, you basically introduce the concept of functional equivalence by expanding already existing the legal framework to electronic documents. And the most important is section 516, paragraph 2. Electronic record having the same function as bill of lading shall be deemed equivalent to a bill of lading, provided that authenticity and integrity of the record are assured at all times. So it's very similar actually to American law. Again, reliability, integrity. And now, most recent text that I found, some German scholars are arguing that German law should also introduce the concept of control, because this happened before Anstral model. So we can divide the stages before and after Anstral model law. So after Anstral model law, there is a need probably for harmonization and for introducing the concept of control, and German law at the moment does not use that concept. Singapore, very advanced country in this area. Singapore Electronic Transaction Act 2010 was revised after 2017, but they gave you a list of countries. One of them is Singapore, and Singapore is already having law and is using in practice, that's what I've heard, providing for legal recognition. Basically, it's based on the same premises as Anstral model. So basically, it's copied with one difference, which relates to this integrity. The main difference is that Singapore law provides that the method is deemed reasonably reliable if it's used by a system provider authorized by the government. Because Singapore is a country where the government wants to control everything. So this is one area that would provide kind of security, because you would have government certifying that this is secure. So that is something which, but this is not in contrast, because model law does not prohibit this. It's just a development based on a national policy, which I think is fine. Japan, of course, coming from Japan, I should say something. Japan, they're very close, and there is a discussion. Usually, when you want to adopt new law or revise existing law, Minister of Justice is in charge. So Minister of Justice will create a kind of expert group, usually consisted of scholars, practitioners, and just specializing in particular area, and then they would discuss. And now they have this kind of committee. And we expect that the final bill will be next year. So maybe, you never know with Japan, because Diet is Japanese name for parliament. Parliament has priorities, and sometimes it's difficult to push legislation unless there is some lobby group, and very often you need push from business groups. That's how Japanese system works. If you have a business association, KDRN, saying we need this law, then it will pass through. It will pass through the parliament. Japanese are focusing on bills of lading mainly, and more recently, warehouse receipts are introduced. This, in a way, this corresponds to document of title as understood by UCC. These are two documents of title under UCC law. Because under English law, because bill of lading is only shipped bill of lading is only a document of title recognized by common law. We have factors which goes further and includes warehouse documents. But under English law, common law, at the moment, shipped bill of lading is the only document of title. American law is different. They accept warehouse receipts. So, because Japanese are very much influenced by, they're looking always at United States, they use this kind of two documents which correspond to American UCC, document of title. So there are two proposals which leads to this. Actually, that is something that is at the moment is unresolved. Should the concept of control be defined or not? So that the opinions are divided. One group says we should define it as the state of being able exclusively to use electronic records, which I think makes sense. Another is let's leave it. We don't have to define it, because model law did not define it. Nobody has. That is actually the problem. In American UCC, you can find the term control in several provisions unrelated. So what is control? This is something which needs, in my view, needs kind of. If I would be asked, I would go for first solution. You have to define what is control. Otherwise, you say control, but what does it mean control? And we come, this is a central part of my presentation. It was kind of introductory part, and we come to English law, which, as I said, it's adopted in July. It received royal assent, which is a requirement, and then it will enter into force next week. So this is a very hot topic. You'll get a lot of text. I'm writing two texts on this topic at the moment. One is about English law, another is broader. English law, I think I mentioned that I was in Tel Aviv in July, and I was sharing floor, now I'm sharing with Patrick in Tel Aviv. I was sharing floor with Louise Gulliver, who was heavily engaged in the process of drafting, and she was a strong supporter of UK approach. So I tried not to be critical because I want to fight with her, but she's a nice lady, and she borrowed some slides from her. Okay. So I think this slide actually asked her to send the slides, and a few slides actually borrowed from her. Because she is the one who can explain what is the position of law commission, because she is not an independent scholar saying frankly her opinion. She is representing the opinion of UK law commission. Documentary intangible, hybrid paper, tangible, and right intangible. So it's kind of hybrid document. Transfer of paper, delivery, endorsement, and delivery. Transfer the right. Okay, these are everything clear. Delivery, transfer of possession. A document, and this is very important actually, and that was a very strong argument when she was making her presentation. She heavily emphasized this, that you have, Patrick has mentioned, I think bills of lading are used for centuries, and there is a lot of case law, and that is one of strong arguments for the approach adopted by UK. You cannot throw away those case law, particularly something which relates to possession. If you can download, you can read the law commission report on internet. I think probably 1/3 of report discuss possession. To justify why instead of control, that's actually the main issue when we discuss UK law. Why instead of control, which is adopted in all other jurisdictions, UK Law Commission has decided to keep possession even in case of intangible documents, which was not possible until now. So basically, what is the main consequence, the main result of the UK law is recognition of possession in electronic environment, which was not possible until this law. So I think that this will bring revolution in English, something really important. Okay, we can have some reservations. I do have some reservations, but I'm not complaining about final results, because you can achieve same results by different ways. And in British English decided to go their way, and I'm fine with that. So this is also a slide that I borrowed from Ms. Gulliver. Electronic document intangible cannot be possessed as it is intangible. That was possession problem. So what is now consequence that instead of cannot, it's now can be possessed even if it's intangible. That is the main result of the new law. None of the consequences of possession can apply to it. That was before this law. No, that was very emphasized by Gulliver, no functional equivalence. We don't accept that concept. Electronic documents cannot be possessed under current law and have the same functionality as paper document. To solve this problem, the easiest way, that was kind of background before Law Commission report, basically the courts were, when, as we would say, when you give hot potato to someone's hands, I don't want it, don't touch it, leave it to Law Commission. So that was a decision by this court. While there were powerful arguments for extending possessory rights to intangibles, it was more appropriate for such a reform to come from Parliament after consideration by the Law Commission. Basically, the courts is directing. We cannot do it. We understand there is a good, solid basis, but this should be decided by the Parliament, and Law Commission should play a role. That was background of the UK law report, because the courts were reluctant to enter into this area, kind of tricky area. And we come to this Electronic Trade Document Act 2023. Now, so we are witnessing a history, in fact. The Law Commission published a report in March 2022. Immediately I started to read, and I found it quite interesting. They contacted many persons, many scholars, so many people took part in drafting this law. Following agreement by both houses on the text of the bill, it received royal assent on July 20. That was recent. Now it's already Act of Parliament, and it will enter into force September 20, which is next week. So we have now, there is something, discussing something very important, which is still not law in practice, but it's in force. It just should enter into force. And we come back to these documents, which are identified as electronic transferable documents. And this is from UK law report. Negotiable instrument, explaining embodying the right to claim performance obligation to pay sum of money, bills of exchange, and promissory notes. So this is one group of documents. Another is a transferable document of title, distinguishable from negotiability in that transferee of a document receives no better title to the goods recorded in the document than the transferor had. So this is often called quasi-negotiable, because you cannot have better rights than your transferee. In case of negotiable documents, fully negotiable document like a bill of exchange, you can get better right than transferor, as transferee. Which is exception, because in law we have this kind of concept from Roman time. No one can transfer more rights than it has, but there is an exception for that in case of negotiable instruments. Or money, you can find money and it's your money. You don't have to prove how you got your money. Assignable, that is third group, which covers two documents, marine insurance policy and cargo insurance certificates. So basically these documents are identified as electronic trade document. documents. This is new. I think, as far as I can remember, this term has never been used in the past, electronic trade documents. What we have in civil law, this wertpapieren, vrijednospapieri, theater, it covers number of documents. We don't have separate concepts. That is different between civil and common law, because common law has preference for narrow concepts. So you have negotiable instruments, you have document of title, you have assignable documents, you have securities, and you have separate sets of rules for each of them. Why? Because that is logic of common law. In civil law, we have different logic. Civil law has preference for broad concepts. So we have one umbrella, which is called wertpapieren. And all of these documents are actually part of this wertpapieren. Obviously, missing are securities. That would make no sense, because securities is not something that is used in trade of goods. It's investment, it's a different kind of trade. So they are not mentioned. In Amstel model law, they are explicitly excluded. Securities and bonds and shares are not covered by model law. And I think that's understandable. Okay. Yes, this is again I borrowed from Luis. The Law Commission had the choice between three alternatives. What are possible ways to get to functional equivalence? My title is mine, should be a different title. Second, frankly, I don't understand clearly. A person with exclusive control of electronic transport document is deemed or presumed to have possession. Probably there is some meaning in that. But I think the main point is about number 1 and number 3. Exclusive control similar to Amstel model law, or extended the concept of possession to electronic documents. That is adopted by the UK Law Commission. Solution. Electronic trade documents provides that an electronic trade document can be possessed and have the same effect. That is the most important. Expressly stated that electronic trade documents can have the same legal effect as a paper equivalent. Electronic trade document contains same information as a paper equivalent. Possession corresponds to control over digital assets that enables party in control to exercise possessory right. There is a reliable system ensuring that not more than one person at a time can exercise control and transfer to another person. So basically, this is actually something that created functional equivalence between paper bills of lading, paper trade documents, and electronic trade documents. Because there was no, at least that was the argument of Law Commission, exclusive control does not provide for functional equivalence. You need this. And this is that you extend the concept of possession to include electronic trade documents. Why is the UK approach suitable for UK? Because we have to think about these practical reasons. And as I mentioned, there is a well-developed English law, developed over centuries. And if we simply extend the concept of possession to already existing case law, basically this is something which is true functional equivalence. Possession is not the right concept for all digital assets, because that was made clear, because the scope of this law was clearly defined only to these three groups of documents, not all digital assets. As I mentioned, securities are not there. And why they had fine problem with exclusive control? Because this is something where I have some reservation. Possession requires intention to possess. That is fine, because that's possession has two elements. One is to have something in your hands, another is to have intention to have something as your corpus and animus. This is from a law. And constructive possession is different concept from exclusive control. That's something that we can discuss. Okay, it is different, but can be extended. Can exclusive control be used instead of constructive possession, I see no problem in that. I see no problem. Even if it's different, just exclusive control is doing it different way and achieving same result as possession. And that was very, I'd say, English way of thinking, easy way. Instead of creating something new, which would raise eyebrows to some people, you just use something which is familiar. So that was very easy to pass the parliament because it was classified as non-controversial. That is important. At the initial stage, if it's something non-controversial, then it's easy adopted. And that proved in practice. It was just a very fast process. Sometimes it takes years, but this was just 1 year and a half. Report was ready in March 2022, and now we have already law. Why? Because they took this, we can say, smart way to pass the law through the parliament. So that can be also kind of justification for the approach. There are some questions. Extended scope of possession concept has advantage. It preserves equivalence of paper, electronic trade documents in both terminology and substance. That was a major advantage from English law perspective. Another issue is that English are the only ones that use this concept, possession. They say we fall, because actually they made reference to Armstrong model law, saying that we are in compliance in substance. But this terminology is different because Armstrong model law specifically uses exclusive control. English law uses possession. So if in compliance, why is there this difference? Okay, we can say that it's the same result, but there is deviation not only from Armstrong model law, but from all other laws that are adopted. No country would, until now, has preserved the concept of possession. It's not American law, it's not German law, this will not be Japanese law, it's not Singaporean law, and most likely, maybe, I'm not sure for some other common law jurisdictions, but obviously we have some discrepancy here in approach. So we have some reservations by leading scholars. You can find them in the Law Commission report. Expanding the concept of possession is unnecessary. And a concept such as control, which does not imply physical custody and court control, would be more suitable. Very good as leading scholar. And actually I asked Ms. Gulliver about this opinion. I said, Roy has changed his attitude. But this is something which you can find in the law report. I did not invented this. I just quoted from a Law Commission report. Another leading scholar, Michael Bridge, possession will have to be defined in terms of control anyway. I can sign this. Because possession at the end ends up with control, and both scholars are saying that. Basically, why do you need possession? But of course, as you could hear from Ms. Gulliver's slides, there is some justification for using the concept of possession. But at the end, it ends up with control. The control is an essential element of all this story. Possession in the context of electronic transport documents is not defined. Because we have possession in paper documents, but what is possession in electronic environment? This is to be decided by courts. So basically, the parliament or a law commission would have to rely now on courts that they would try to define possession in the new environment. And we are going to see what will happen in the future. Of course, courts very often they stick to public policy. They have preference not to make waves very often. So we can expect that most likely one of in the future cases, because this is still not law, this is already only to be applied in the future. But we can expect that most likely English courts would provide a new definition of possession that would be acceptable in case of electronic environment. This is my anticipation. As BBC would say, the only guarantee is there is no guarantee. We shall see what is going to happen. Something which I don't understand is section 2, paragraph 3. provides that a person exercises control of a document when the person uses, transfer, or otherwise disposes of the document, whether or not the person has a legal right to do so. My question is how a person can transfer document if does not have legal right to do so. Again, probably there is something, but I don't understand it. Because normally, in order to have the right to dispose, right of disposal means right. So if you don't have right, how you can dispose with something you don't have right? Something unclear. I don't understand. Maybe I'm wrong, or simply I don't understand. But for me, this is something which I'm raising questions. I'm not saying this is wrong, but I don't understand it. Reconsideration of the concept of control. Control has not been legally defined, except being functional equivalent of possession. But then, what is control? Because control can mean different things in different jurisdictions. And I think that is something that needs clarification in the future. English law seems to stick to the concept of control as factual without element of intention. And that is what again, I have a problem. The intention is presumed, I mean, particularly when we talk about exclusive control. How exclusive control can exist without intention? Why you would, because to get exclusive right, you have to pay for the goods. Otherwise, you cannot get right as a buyer. And if you don't have intention to own the goods that you are paying for, there is something strange here. But there seems to make this kind of distinction between control as legal concept and kind of factual, kind of fact without intention, and that is something which I don't understand. Can the right of control of the goods be distinguished from control over electronic documents? Because it seems that English law makes this kind of distinction. Right of control is different from control over electronic documents. But my understanding is, of course, I'm maybe too classical, too traditional, that right of control is actually an instrument to have possession. Control over documents is instrument of the right of control. That's why you're getting control, to have your right to get control over the goods. Otherwise, why would get control if you don't have intention? So this is something which can be questioned. At least can be questioned. I have no explanation. If you ask me, I don't know. I'm just raising question because of something that is unclear to me. That's why I'm saying questions. I'm not providing answers. That's another issue that about the control. And control can be exercised in different way. They have different way of control. Even in case of waybill, you can exercise control by giving instruction to the carrier. Waybill itself does not carry any weight, does not have any value. But even if in case of waybill, see waybill, for example, you still retain control over the goods until a certain moment. And you can give instructions to the carrier to deliver the goods to this or that person. So this is also control, but it's unrelated to something which we talk here. It's about exclusive control, which means having kind of right which corresponds to possession right. It's completely different. They're completely different concepts, but both are called control. That's why I'm saying control can mean different things in law. And the issue is how we can define it. Terminology, yes. Is it same if you compare electronic transferable records and electronic trade documents? You can see differences. For example, Amsterdam model law includes check. UK law does not have check. Consignment note, ever bills, they are not there. It seems, according to Ms. Golby, and she is one of the leading scholars, she is also from Malta, and also teaching at Queen Mary, so I met her when I met Zoran, my apology, I said yesterday Shin, it was not Shin, Rix. So I mixed them up. So I met them both, Bernard Rix and Ms. Golby, she is leading scholar. And so she's arguing that stray bill of lading is covered by electronic trade. But if it's covered, we have this definition, may possess, endorse. Can you endorse straight bill of lading? No. So if straight bill of lading is really covered by this law, there should be no endorsement. So maybe instead of and should be something or, make it clear that it's alternative but not all. Because as I think I explained already, straight bill of lading are not negotiable. You cannot endorse them. You can transfer them by assignment, but not. So I think that there is something wrong with the text here. Is exclusive control in model law same as possession in a law commission report? Basically same. Basically same. They are just using different terms. Possession is preferable. I'm talking from position of law commission because it refers to already settled principles, while control more accurately reflects technological aspect. Because actually what is, when we talk about technology, it's about control, right? Having right of control, which gives you certain right of exclusive control. And again, I will refer to Ms. Golby. That's an interesting paper published in Lloyd's Maritime Commercial Law Quarterly, 2021. A difference between model law and English law. That was in time of draft, so it was not law at that time. If under model law, a person asks, can electronic transferable record be possessed? The answer would be no, in contrast to English law. But it can be controlled, and the law treats this as equivalent to possession. So basically this corresponds to what Roy Good and Michael Bridge have said. Under English law, the answer will be yes, because they can be controlled, and that control amounts to possession. So I have different approach, but the end result is basically the same. And then very recent, July, again Miriam Golby, comparing American law with English law. An important difference between the concept of control in the UCC and that in the UK Act is that in the later, control refers to a state of fact. As I mentioned, this is a fact, rather than juristic concept, which makes a person the holder of document at law. So under English law, it's more factual. Control is a fact, while under American law, this is a legal concept. The UK approach seems to assert that the person in control may not have the right of control. That is where I have a little bit problem. That sounds confusing. I mean, if you have, how you can have right of control if you don't have control? It's kind of contradictory. Technologically, that might be possible. I'll leave this open. But the UK should have addressed the legal issues related to the right of control rather than focusing on what might be technologically possible. The UK drafters probably focus on control as an element of possession and requirement for enabling possession to be extended to electronic trade documents. This is my comment. This is not Miriam Golby. Looking for the future, Electronic Trade Documents Act will have strong impact because of relevance of English law. I think I mentioned yesterday that I used to work for a shipping company. Almost all cases were governed by English law. Almost all cases. Very few, maybe some French and maybe some other, but basically I think Ms. Gulliver mentioned that 80% of all cases is English law. So when you have English on one side, this is something which will have impact, regardless of all other jurisdictions, cannot be ignored. Is there need for harmonization of the concept of control? You can see that in Japan there is this dilemma. We should leave it open or we should define it. That is something that I don't have clear opinion. If you ask me, I would say probably there is need because it's not clear what does it mean control. And then probably I would go for a proposal made by Japanese scholars. You explain what is control, what you mean by control. I think that makes things more clear. And something which is, I think, the last message that from this lecture is what is essential is to achieve the same result, not necessarily in the same way. I think that's important. It's an important message. Thank you.